So the next type of interest that we're going to discuss in regards to current real estate ownership by your clients, husband and wife in this particular example, they own a property with another couple, for example, or another person as tenants in common, where the husband and wife's interest is separated specifically and reserved for the husband and wife. Whereas if husband and wife pass away, their share is going to pass through probate court. It's not going to pass to the other co-owner of the property because it's not held in joint tenancy. Joint tenancy does offer that right of survivorship benefit for joint tenants in California, but not right of survivorship is not available for tenants in common. So that's why individuals who own property as tenants in common, whether it's an individual or a couple, should put their interest into a living trust so that it passes through probate. That particular interest of the couple, let's say it's a 50% interest, will pass through probate. So let's go do that example. Hold on a second, that's not what I wanted to push. Go next. And so you would choose, well, first of all, find out whether or not you want to get an explanation of real estate ownership interests. If you want a detailed explanation, look at the menu explanation graphic there. And for further in-depth information and explanation and demonstration, click on the video links. Either one of these two are the same concept video explaining what those ownership interests are: outright ownership, partial interest, or joint interest, as used in the context of setting up this trust transfer deed. So usually you'll come to this page showing no selection here. You do have to make a selection here. Partial interest, we already discussed outright ownership. Partial interest, which is essentially tenancy in common. Okay, the clients own the property with someone else or another couple on title. And let's just say, for the sake of demonstration, the couple owns a duplex with another couple. One couple stays in one side of the property, one part of the duplex. The other stays in the other duplex, the other part of the duplex. And they agreed to go 50-50. So they have 50% ownership as showing on title as tenants in common. How is the property currently vested? Let's just say it's in both names. And you have to then fill out the information here accordingly, as I described before. If that property is only, if that 50% interest is only in the husband's name or the wife's name, but the wife or the husband who is not on title should be on title, you'd select husband's name only because that 50% tenancy in common interest is only in his name, or let's say it's in the wife's name. Then you can enter the information as to how that wife's name appears on the title exactly on that deed. Verify it's spelled correctly. Indicate whether it's a primary residence. If it's not primary residence, leave it blank. Parcel number, address, county, state, zip, city. And if available and strongly encouraged, have the client give you a photo or a copy, or you take a scan of the property tax bill just for final verification purposes of final ownership. And then we'll be doing a quitclaim deed for that transfer of the tenancy in common interest into the couple's living trust. And at that point now, instead of only being in the wife's name, that 50% interest, it will now be in the husband and wife's names as trustees of their living trust as to an undivided 50% interest. Of course, don't forget the legal description. Do your best to get the accurate legal description. In the end, don't worry if you don't have it. Just say, type in don't have, and then we can go ahead and verify the proper legal description. We always do our due diligence here when you after you submit this questionnaire to confirm correct legal description. Sometimes it can get complicated to make sure or ensure that we have the correct legal description for a given California property. Other than that, that pretty much explains this part. Again, tenancy in common interest is when multiple people own a property and each homeowner or each person or couple holds that property, that percentage outright, and it's not subject to right of survivorship as with a joint tenancy. Okay, and it will say, well, on the deed, it'll mention usually percentages of ownership for each of the tenants in common. If it doesn't say joint tenancy, it's automatically construed to be a tenancy in common. In order for this to be a joint tenancy in California, joint tenancies must say that the property is held as joint tenants. If it doesn't, it's a tenancy in common, and you would choose partial interest if the clients are not the only people on title. Hope that helps with that explanation of how to fill out this particular option of the trust transfer deed. And we'll now move to the final tenant's property title interest.